Good afternoon, ladies and gentlemen. I'm going to quickly run through some statistics on last year, just to give you a feeling for the backdrop in which we see this new legislation coming in. Then I'm going to give you some of my own views on the new legislation, and then run quickly through a case study for a personal insolvency arrangement. So briefly, to run through some of the statistics from last year, the corporate statistics as much as anything else. We saw a marginal fall in creditors' voluntary liquidations last year, about 5.5%. Not a huge amount in the grand scheme of things, certainly in circumstances where in 2011 the figures had reached their highest point ever. We saw a significant drop of 20-odd% in court liquidations, but that's probably as much as anything to do with the cost of entering the court liquidation process, coupled with ongoing threats by the judge involved to tax quasi-receiverships through the court process with some form of stamp duty. In terms of members' voluntary liquidations, we saw a significant fall. These are solvent liquidations, and I think as much as anything, these are that fall is probably indicative of anyone who's already out is out, and as a result, the numbers have fallen significantly. Examinations rose up to 27. Still a very, very low number, considering it's our only major restructuring tool, and but it is a very effective tool when it's used, and it can be done quite cost effectively as well. So it's still disappointing to see the numbers languishing down at that level. Corporate receiverships increased significantly. As much as anything you'd expect, this is as a result of a lot of the banks gearing up, certainly some of the foreign-owned banks preparing to exit the country. Bankruptcies, as we mentioned earlier on, in the context of the overall corporate insolvency rates, they remain ridiculously low at only 33. I know I've ignored arranging debtors for the purpose of this, but as you can see, only 35 bankruptcies in 2012, only 33 the previous year. Those figures, though, they hide something. The reality is that we don't know how many sole practitioners or partnerships actually failed during the period. I mean, we might be able to get indicative numbers from the revenue commissioners if we looked at tax registration or deregistration, or if we added up all the clients that have disappeared to all the auditors and accountants and lawyers in the country, we might have an idea. But as it stands, we just don't know. Same with personal asset receiverships. Those numbers are hidden away in the central bank somewhere. They're not something that's publicly available. So just to briefly run through my own view of the new legislation. Well, it is a long overdue update. As we mentioned earlier on, the last update was in 1988 and it really wasn't taken up on at all. The reality is, though, that the timing update is extremely poor. Not so much that the legislation wasn't inevitable, but the reality is that now that the government, in terms of revenue rates, or none of the banks can actually adhere or allow wholesale debt forgiveness at this time. It is a very considerable improvement on the personal insolvency legislation that was previously in existence. It's not perfect, not by a long shot, but it is a very significant improvement. It does appear, on the face of it, to be a very favourable alternative to people leaving Ireland. The reality is, and thanks to Alan for dispelling some of the myths, I mean, the reality is we don't really want people leaving Ireland. We don't want to keep them here, and other banks don't particularly want to see the customers leaving, because in the long term, all it does is impact their business, because the less people who feel they can get a deal done here, the more likely they're going to bail out of the country, the less likely they are to do business with that bank in the future. The legislation is drafted to prevent bankruptcy tourism into Ireland because there's a reference in the legislation about residency in Ireland. I'm not quite sure if that's tax residency or passport residency, but the reality is either one would involve if you happen to be in the country for a continued period of time before declaring. The laws are drafted to prevent is the wrong word, to avoid multiple uses. That's not to say you can't declare under different forms of insolvency more than once, but there is time gaps between them to prevent people just bouncing in and out of the procedure. For obvious reasons, once a debtor enters into or obtains a protection certificate, there's no entitlement of a creditor to continue a legal action against them unless they obtain court consent. So obviously, for obvious reasons, there's no point in giving someone protection if a creditor can just continue their action against them. The Seanad made some very important changes really at the last minute that up to that point have been quite an area of bone of contention for a lot of people, including myself. They gave certain clarity over pensions and what's protected and not protected. They brought in a split between what's considered excluded versus excludable creditors. Previously, basically anything that fell under a state tax or a state fine was excluded. Now, subject to agreement in writing from the Revenue Commissioners, the rates, they can actually be written down. Previously they couldn't be. The other important area was that the Insolvency Service are now under an obligation to prepare living standards for someone entering one of these procedures. The UK has similar living standards criteria set, but it was interesting that it took the Shannon at the last moment to really put that suggestion forward. The time of the commencement, it remains unclear. The reality is we understand that we're going to be seeing the first of these in the next quarter. I still have my doubts we'll see them running. There still seems to be quite a bit of work to do, but I think we can take it for granted that we're going to see the schemes started this year. I think, as we mentioned earlier on, banks were more than likely going to be the largest unsecured creditors, are going to retain a considerable influence on the process. Another area of problem is there's going to be costs involved with any of these schemes. That is an obstacle to someone entering it. They need money to enter into one of the schemes. And there's also the area of preferential creditors, where there's nothing set which says they have to take a write-down. So again, that may run into thousands of euros that needed to be available to the debtor before they can actually even embark on a scheme. And as I mentioned, the attitude of excludable creditors, in particular at state, in terms of rates, revenue commissioners, remains unknown. Irish personal insolvency, even under the new regime, 3 years for bankruptcy, potentially 7 years for personal insolvency arrangements, 6 years for debt settlement arrangements, it still remains punitive in terms of legislation in other jurisdictions. Now, obviously, I'm ignoring the set-up time in terms of looking at these numbers here, because I heard recently of a gentleman who spent over a year trying to get his COMI established in the UK. On the face of it, in terms of the actual in the process, we're still behind the curve. I'm going to allude to this later on in my case study, but I think certainly the key to a successful scheme, whether it be a debt settlement arrangement or a personal insolvency arrangement, is going to be to secure the support of your largest creditor in advance. There's no point in entering into a scheme unless you know how they're going to vote. The new legislation, as I mentioned earlier on, you need money to get one of these schemes off the ground. If you don't have money, it's not going to work for you. The other area is, if you don't have a job and you need to emigrate, there's not a whole lot of point in you looking towards the Irish insolvency solutions, when it may make more sense to you if you're going to be living in England and working in England to just grab a hold of a personal insolvency practitioner over there and declare bankruptcy or enter into an IVA over there. As a result of the above, the insolvency numbers remain difficult to predict. I think the Minister is, in terms of what was mentioned earlier on, I think, quite frankly, that's optimistic. I don't see those kind of numbers in the opening years. Maybe in the longer term, certainly in terms of if you were to pro-rata our population versus UK and Northern Ireland, we should be looking at over 10,000 insolvencies across the range of processes each year. I just don't see that. So that brings us on to Mr. A, our case study for today. Now, I think in your pack of documents there you should have a spreadsheet which has a load of different figures. I don't propose to go through every one of them, but to basically give you a background to this man's financial position. One thing I'd ask you to do is, in the middle of it there's a column entitled tax. We're going to do what a lot of people have done in the last while, we're going to ignore the tax man for the moment. So if you can just put a line through that, because frankly if I was to bring in the tax man preferential creditors, we'd be here for a lot longer than we have allocated. So Mr. A, well, he's in financial difficulty, as we established before. Also, we're going to have an element of suspension of disbelief for a moment, because we're going to have not one but two banks who are supportive of this scheme, and we're also going to have an unencumbered property which the banks haven't already got their hands on in advance of the scheme coming to pass. So, Mr. A, his properties are now worth 2.3 million, but his borrowings are in excess of 4 million. And I'm only looking at his own personal properties at the moment, and not the greenfield site at the bottom of that spreadsheet. He's doing his best. He's paying all the interest, he's paying all the expenses, but he can't get anywhere near funding all the capital. In fact, out of his own personal income, he's got about 71k, which he's passing towards the banks on a yearly basis, but he should be paying them 258,000. And even though he's taking a further 29k from his net income, his personal salary, he's still getting nowhere near his capital requirements. As a result, it's going to take him 40 years to clear out his debt to his banks at the moment, which in real terms just isn't realistic. This is coupled with mounting credit card debt. So Mr. Ray, as we mentioned earlier on, he approaches a personal insolvency practitioner to get a scheme up and running. The PIP is under an obligation to consider whether the gentleman is actually insolvent and will be insolvent for the next 5 years, in taking into consideration all sorts of assets and liabilities, his current liabilities, contingent liabilities and the like. In this circumstances, Mr. A's wife, Mrs. B, she's not going to join in. Mrs. B is doing all right for herself. She doesn't have to join in to this process. She can, however. There can be joint proposals, and I could certainly see a scenario where husband and wife will enter into joint proposals, or you may end up seeing guarantors siding in and going into a scheme as well, to the point where we may actually see the phenomenon of multi-generational schemes arrangement, where you've got maybe a father and their son, where the father is to guarantee the debts of the son, entering into the same scheme at the same time. Just to clarify that point, if a debtor goes through this process, guarantors don't get out. They're still on the hook for the debt. So to kick off the process, Mr. A, he hasn't entered into any form of personal insolvency previously. As I said before, you can, but in this instance, just for clarity's sake, he hasn't. He's cooperated with his bankers to the extent possible, and he signed the statutory declaration on his cooperation. I haven't actually seen this statutory declaration yet, but I'm assuming it's going to be along the lines of an undertaking. In our example here, his secured debts are in excess of €3 million. Now, that of itself would put him outside a personal insolvency arrangement in the normal course of events, but in this scenario, the banking creditors have actually agreed in writing that he's entitled to enter into the scheme. Mr. A is domiciled and resident in the state, so there can be no question about his entitlement to enter into the process here. But he is insolvent, and that's the bottom line. He has to be insolvent to enter into the process, regardless of how many creditors you have, whether it's secured or unsecured. So Mr. A has to complete his statement of personal financial statement. Now, we haven't seen this as of yet. I assume it's going to be a lengthy enough document along the lines of what we see in Northern Ireland or in UK legislation, but we haven't actually seen the final document as of yet. So Mr. A, he arranges for the PIP to notify all of his creditors and tell them that this is what's going to happen. To notify the Insolvency Service to tell them that he's entering into a scheme of arrangement with his creditors. So the Insolvency Service gets in the application and they've got some queries. So the first thing they do is they write back to the personal insolvency practitioner and they say to him, well, actually, can you clarify certain matters? In this regard, Mr. A's pension is in question. So Mr. A's employers, they're under an obligation to provide this information to the Insolvency Service. The Revenue Commissioners would also appear to be under an obligation to provide this information to the Insolvency Service. Now, on the face of it, that would mean that the Insolvency Service seems to be immune from data protection legislation, which I don't know whether ultimately that's something that will come up down the line. But on the face of it, that's my reading of it. So anyway, in this example, the Insolvency Service, they get all their answers, they're happy with what they hear back, so they go in front of the judge. The judge rubber stamps the protection certificate, and Mr. A is given his 70 days protection. So once Mr. A has gotten his protection, it's up to the PIP to then notify all the creditors of this protection certificate. Included in that, they also have to tell the creditors of the implications of the certificate and advise them of their rights of entitlement to regard an appeal. I could see that letter ultimately becoming something very standardised, and it's just spewed out by whatever insolvency software is ultimately used. So as part of his obligations, the PIP is obliged to seek from the creditors their views of Mr. A's finances and the proposals. So if you just have a look at that spreadsheet for a moment, you see that Bank 3 aren't a huge creditor in the grand scheme of things, but in this particular instance, they've grown sick of Mr. A dallying around and not paying their credit card debt back. So they'd actually gone as far as to issue proceedings against him. Now the reality is that action is automatically stayed as a result of the protection certificate being granted. The reality is, though, Bank 3, looking at the quantum of money involved, they decide, and they know now the proposal is coming to them, which they didn't have previously. They decide, well, we're not going to appeal it, and we're going to wait, and we're going to see how the scheme pans out. Now, oddly enough, in this instance where Mr. A has large secured creditors, it wouldn't actually suit them to go ahead and get a judgment mortgage against Mr. A, because effectively they would just be a very small fish in a very, very big pond. So in this circumstances, Mr. A he's kept detailed financial records, and I can certainly see this being an area of problem as regards to the 70-day time limit. If his financial records aren't great, and the insolvency practitioner has to write out all creditors and try and get all the financial information off them in advance of trying to put a scheme together. So, possibly on the back of negotiations in advance of the actual application, Bank 1 and Bank 2 have already given their preferred treatment of their properties to the insolvency practitioner. In this particular example, Bank 1 don't agree with the PIP's valuation of the Greenfield property. Now, there's criteria in the legislation under which there's an argument between the PIP and the bank can be resolved as regards the valuation of property. It extends to the point where ultimately the insolvency service would send out a valuer to conduct the valuation. In this particular scenario, we're just going to lob an estimated sales price into the scheme, because we're all agreed that the property has to be sold, and when it's sold, that's the figure that will ultimately for the payment process. So the PIP has conducted his due diligence, and after examining Mr. A's finances to a large degree, he's going to put the following proposal forward. So in terms of Bank 1, sell everything, absolutely everything, just sell it, get it gone, crystallise the debt that's outstanding, and get as much money back to Bank 1 as physically possible now. Now, under legislation, it basically says that Bank 1 are entitled to the market value of their security. In real terms, I can ultimately see the bank, when there's no other assets or cash available, the bank are going to end up footing the cost of any sales process, whether that be the legals, whether it be the auctioneer, whether the rates that are outstanding. But for the purpose of this example, Mr. A, he has his 20,000 euros in his deposit account, so he's going to use part of that to fund the costs of this transaction. In terms of Bank 2 then, Bank 2 is an interesting one. Bank 2 is Mr. A's personal residence with his wife. There is an obligation on the personal insolvency practitioner to prepare the scheme on the basis of keeping Mr. A not just in possession of his family home, but also in ownership of it. So that means he gets to stay in the home. In this instance, he's waiving that entitlement. Why is he doing it? Well, he's doing it purely so he can get some financing in from his wife. So it can be done. He has to take appropriate legal advice, but it can be done. So after all said and done, as you can see, there's not a huge amount of equity in the family home per the spreadsheet. So Mrs. B, Mr. A's wife, is going to pay 20,000 euros into the kitty here. The excludable creditors. As I mentioned earlier on, the excludable creditors can basically say, well, we're not going into the scheme. They can refuse. Now, I can see that being a big problem if the revenue commissioners ultimately decide that they're not going into a scheme when the gentleman might be a trading entity and a sole practitioner, where he's run up a tax bill, and then the revenue turn around and say, well, we're not entertaining any kind of write-down, and as a result, a scheme will never get off the ground. In this particular example, the rates liability isn't hugely punitive. It's only 14,000 euros. So as a result of the additional money that's come in from Mrs. B, Mr. A has 14,000 euros available to him to pay the rates liability in full. And lo and behold, there's a few bob left for the personal insolvency practitioner. So the fee agreed 6,000 euros to go through this process, and an additional fee of 1,000 euros to prepare the update year in, year out thereafter. It's not a huge fee in the grand scheme of things, and in terms of the amount of money the amount of work I'd have to do to earn my 6,000 euros in this scenario, as opposed to the amount of work I'd have to do to earn 6,000 euros in a liquidation. You can take it for granted I'm not going to give up my marketing for liquidation work anytime soon. But I honestly believe this will be very much a cost-driven business. Certainly in the UK, the phenomenon of insolvency factories came to light. We may well see that here ultimately in the long run, but for the moment, I think it's certainly not going to be as lucrative a market as you might otherwise think. So, in terms of the unsecured creditors, after the sales, it's envisaged that Mr. A is going to have unsecured creditors of about 1.843 million. Still a pretty chunky amount of money, but effectively that's what's going to be the residual. As part of the process, again, to try and raise some funds, Mr. A has agreed to sell Greenfield property to his wife. That's property, from recollection, it's worth about 200,000 euros. So, Mrs. B is going to pay her husband 86,000 euros for his share. Now that's below market value. No creditors care. The reality is that they take the view, well, the site is behind the family home, it can be very awkward to sell. The reality is if we go to market, we could end up having this thing on the market for months and there's no money available at all. So creditors are happy enough to let it go at that price. So after payment of expenses, Mr. A receives 80,000 euros in. So what does he do with the 80,000 euros? Well, he pays it out as a first dividend to his creditors as follows. As you'd expect, Bank One swallowed the vast majority of the payment. The reality is, though, that this is described here as a first dividend. Let's just say Mr. A, for example, was able to come up with 800,000 euros. There's nothing here to say that he couldn't put all that money in the kitty straight away, do a one-off bullet point payment or settlement with his creditors and have the scheme over and done with in a matter of days, a matter of weeks, and be out on the far side. The reality is the legislation, while it shows the maximum periods involved, it doesn't stipulate a minimum payment that's due to, it has to be made to creditors. It doesn't stipulate a minimum period. So the door is really wide open. But if the creditors accept it, then the scheme will go through. And that's the most important thing. The legislation hasn't really put criteria on it that says you have to do this, you have to do that. If the creditors accept it, then the scheme can go through. As you can see in this particular example, the dividend isn't exactly great on the first chunk of cash, at only 4.34%. But in this example, the creditors seem to be happy enough with it. Mr. A, as a emergency, this is a PIA. PIAs tend to be 6 years, but there's an option to increase them to 7 years. In this example, we're just using a 6-year period. So this is the dividends thereafter. As I mentioned earlier on, Mr. A has got about 29 grand from his salary, which he can make available to his creditors. So he's going to continue to make that available to his creditors year in, year out, and they get an extra drip of a dividend of 1.57% payable to them. So that's what we're looking at over the life of the scheme. It's a fairly sizable debt write-back down as a result of the process. And again, we're back to this element of suspension of disbelief about whether you can find a bank who's going to be willing and happy to write off 1.5 million euros that quickly. Long and short of it, as I said, there's no set criteria on the dividend prospect, so 13.78%. If it was a corporate liquidation and the creditors were getting 13.78% back, they'd be very happy because most of the time they get nothing. So from that point of view, it's not a bad scenario. Now Mr. A is signing up to a scheme which involves him agreeing to make a number of payments over the next couple of years. How's that going to be financed if something happens to Mr. A? So I could see a scenario easily enough where a bond or life insurance policy can be taken out as a guarantee for any creditors who enter into this scheme and to make the payments out to them. So, on to the meeting of creditors. Now, for the purpose of this example, I'm ignoring the whole row about the validity of proxies and whether the banks are going to be able to or willing to sign off on a proxy or get it in on time. So for the purpose of this, we'll just assume everyone managed to take their advice, get their proxies in time, and as a result, they're all entitled to vote at the meeting. So the PIP was given as 14 days notice to creditors. The Rates Authority, obviously, they've refused to allow themselves to be included in the scheme, so they won't be voting in the scheme. Now the creditors, they've gotten the scheme in advance. They've sat down on the day with the PIP, and they've agreed to the scheme. They haven't sought modifications. I can't easily see a scenario where you're going to have a solicitor there, probably a PIP, and maybe amendments being handwritten to the scheme as we go along. So, the voting. As you can see, we've got are over our 50% of our secured. We've got over our 50% of our unsecured voting in favour of the scheme. And we've got a small amount of unsecured creditors voting against. So, as the puppet master behind the scheme, being the PIP in this situation, I'm very happy with the way things have turned out. I've got my approvals. Mr. A is obviously happy enough. He's gotten his approvals as well. He can see the scheme. He knows is what he wanted is agreed. Bank 1 are happy because they've agreed to it and it's happened as they saw fit. And Bank 2, well, they're happy enough as well. They've seen the refinance. Bank 3 aren't so happy, and neither are the utility company. In fact, the more they look at this, the more annoyed they get, because, frankly, I, as the PIP, firstly, the thing I've done is I've let Mrs. B vote. Mrs. B is a connected party. She is barred from voting at a meeting of creditors. So, straight away, a bit of doubt over how well I've put this scheme together. In fact, oddly enough, Mrs. B could vote against the scheme. I'm not quite sure why that is, but she can't vote for it. Bank 2, well, there's a bit of doubt about their entitlement to vote. They're getting refinanced. They're getting taken out of the picture here altogether. So why are they voting? The biggest debate, though, has to be around my split of the secured and unsecured voting for voting purposes here. Bank 1, we clearly see it, are in terms of ultimately after they sell their property, they are going to be very substantially unsecured. There's a large amount of money that can be shortfall there, 1.8 million. In terms of the drafting of the legislation, Bank 1 are a secured creditor, and therefore they should only stand to vote under the secured creditor heading. What I've done here is I've manipulated the scheme to enable me to secure the voting levels I need to guarantee the scheme goes through. And I'm sure some of you are there thinking, well, this is terrible stuff. Mr. Leydon has made a hames of this scheme. This is bound to be objected to. Well, the reality is, I'm going to say something to you that I hear very regularly at creditors' meetings. If you're not happy with the scheme that's put forward the PIP, you have to go to the courts to do something about it. Now, if you're representing Bank 3 and utility companies, you're not big creditors here. Not a big sum of money. Is it going to make that much of a difference to you if you go to spend the money to challenge the scheme? It's hard to know. It's hard to know. But these schemes are capable of manipulation. I think we're definitely going to see a lot of people challenging them in the forecourts or in the courts for the first couple of years. And certainly, when something is as blatant as this, you're definitely going to see some measure of challenges if it's financially worth the creditor's while to challenge. Let's just for a moment skip to an alternative reality where the scheme had been somewhat properly constructed. We now have in excess of €4 million voting in favour of the scheme. We've got a creditor who is worth literally 0.5% is objecting. Your creditors worth 0.5% are voting against the scheme. So 99.4% in favour of the scheme, 0.06% against. The scheme fails. Now, that of itself is a ridiculous scenario to allow happen. But the reality is that is the way the legislation is drafted, because I don't have my 50% of my unsecured. In fact, I've got 0 unsecured in favour of the scheme because Mrs. B shouldn't be entitled to vote. I think it's without a doubt we're going to see banking arrangements amended to enable, in circumstances where a bank is in favour of the scheme, I think there's no doubt we're going to see banking arrangements amended to ensure that if a scheme is put forward that it's going to be successful. As you can see, it's quite easily done.